On May 19, before and during the symbolic signing, Mr. Cummings was not the chairperson of the CPP. Not at all. It was subsequent to the May 19, 2020 signing that Mr. Cummings assumed the leadership of the CPP. When he assumed the leadership of the CPP, the ALP Bernard Euro, who was the chairperson and organized, supervised the May 19, 2020 signing, presented no document to Mr. Cummings. Presented no document to include even the unsigned May 19, 2020 document. Because each party, each political leader in his separate location had a copy of that unsigned document. That was a symbolic signing. So there was no need for Bernard Euro to have submitted any copy to Mr. Cummings. He made no turnover of any other document to Mr. Cummings. I challenge him to produce the 10-word notes. There and then, Mr. Cummings assumed the leadership of the CPP after the May 19, 2020 symbolic signing. The unsigned May 19, 2020 document was not given to the team of lawyers to review. I indicated they reviewed it, they revised it, they amended it, and they developed 10 key issues. Same Mr. Cummings was the chairperson at the time, they submitted those 10 key issues along with a revised version of the May 19, 2020 unsigned document to Mr. Cummings. Mr. Cummings then submitted it to the political leaders and the chairpersons. On July 23, 2020, the lawyers, on the request of Mr. Cummings, did a presentation of the revised version and had a discussion of their 10 salient points with the political leaders, chairpersons, and all concerned individuals at the Liberty Party headquarters. The amendments were made, they were accepted, they were endorsed by the constituent political parties. It will interest you to note that even the resolutions of some of the parties are dated after July 23. They are dated after May 19, 2020. So you cannot be contemplating to sign a document May 19, 2020 and do a resolution in July. Practical impossibility. Now, when the revised version of the document was accepted and approved and resolutions were adopted by each political party and submitted to Mr. Cummings, Mr. Cummings now proceeded through the secretariat of the CPP at the time to file that revised version, the one that was revised, that was amended by the lawyers, with the National Elections Commission, with the consent of all the constituent political parties, along with their resolutions. The document was filed, all the parties relied on that document and participated in the by-elections. Their parties won seats on account of that instrument. Subsequently, Mr. Bernard Euro now claims that Mr. Cummings altered the May 19, 2020 document. How could he have altered May 19, 2020 document when you submitted that document to lawyers for revision and amendment and you endorse their amendment? Another practical impossibility. Let me bring you to the final point with respect to the evidence presented to us by the prosecution. The evidence, as we have seen, presented to us by the prosecution on this court, they have no iota of truth. Because the self-same documents that are in their possession and that they gave us are the self-same documents that are in the possession of all the constituent political parties. Same documents, some of which we have named here to you. The original May 1920 document signed symbolically via Zoom that has no single signature page of all the parties. The revised version that was done, amended by the lawyers, and the final version that was filed with the Elections Commission. Those are the documents. The resolutions of the various political parties authorizing the leadership to execute the framework document. The evidence is wanting. And that's the more reason why they have calculated, well-planned the subpoena to put the public under the impression that Mr. Cummings has something to hide and that he has a document that he's hiding, because there is no document that has been altered. And for you to prove fraudulent, conspiracy, fraudulent, you must prove what was altered. You are not saying somebody's signature was changed, somebody's signature was forged. No, you are saying that a clause in the agreement was changed, meaning there is an original one that has this clause, and there is one that was altered. So the clause in this one was changed in this one, and this one was filed, this other one was not filed. That's why you are saying technically. So those two documents must exist. And it goes to the heart of the prosecution's case. I am very much confident, ladies and gentlemen of the press, about Mr. Cummings' integrity, his reputation, his innocence. I am confident about the innocence of the other two defendants, Senator Nathan and that of Aloysius too. And I have said and maintained that truth, or the truth crushed beneath the earth, will rise. As a practicing attorney, we do not give assurances to our clients. But when we review the evidence, as we have done in this particular matter, we are very much confident that at the end of the day, the truth will prevail and the defendants will prevail. We have now requested the court for an assignment. We hope that will be done, and as early next week, we'll be back in court to pursue this matter. The attempt by the Solicitor General and his collaborators to delay this trial so that the public does not get to know the truth, or we do not go to the merit of it, will be resisted. I want to thank you all. We'll now entertain questions and answers, and my colleague here, Anthony Gould, will also respond to some of the questions. And so, thank you very much.
So if you have a question, just give me notice, then I will recognize you, and then you place your question. Okay, so but I want to get the first opportunity to one of the two females in the house. Yes. What's her name?
Yes,
please take your name and place your question.
My name is Magdalena from Truth FM. So some members of the public they refer to this as a political trial. Do you see it as a political trial?
Oh yes, I do see it as a political trial. I think it has a political undertone. The reasons are just to hold to all this. No, there are cases in this country of murder that require death penalty. There are cases of rape. There are capital offenses that are being committed. The Solicitor General puts no emphasis, no concentration, no focus on prosecuting those cases. But he is involved with a case that is what? First degree misdemeanor. And as I told you, let's assume there is a conviction. The fine is not more than $1,000. The imprisonment is not more than 4 months. Do you see? More so, the resources that is being put into this matter, we are aware. Thousands of dollars is being given to his office, and he's utilizing it. You were in court, in the circuit court the other day. He said it clearly. He said, I'm being well paid for this case. Oh, he's not being well paid as a solicitor general to prosecute murder cases, to prosecute rape cases. But he's being well paid to prosecute Mr. Alexander B. Cummings and others. So I do agree.
Have you seen any private lawyer associating with the state on this matter, as is done with other criminal cases where the private prosecutor will have their own lawyer to associate with the state? The state is bankrolling this. So one would be justified in saying, this is a state-sponsored trial. It's a political trial. It smells like it, looks like it, it feels like it.
Okay, no question. Okay.
Yeah, I'm Elijah S. Moses. I'm concerned with the public listening that there is a document filed to the court. Do you care to inform us which one of the documents that you put filed to the court? Was it a May 19 document that you were ordered to produce within the 72 hours, or which one of the documents you sent to the court?
Thank you very much. I think I may have explained it, but I can go back to it. I will call the document that the court ordered the defendant to produce, I will refer to it as the subpoena document, right? So to answer your question correctly, we did not submit the subpoena document because that document has never existed and does not exist. Why we submitted, what we submitted, and why we submitted what we submitted. We submitted the May 19, 2020 document that was revised and amended by the lawyers, approved by the political parties, signed by all the political parties based on the resolution of each of them, filed with NEC on July 14, 2020. And that document is with NEC. They can subpoena NEC. They can have it in fact, because in this list of documents that they presented to us, that document is also attached. That is the document we presented to the court to say, look, the subpoena document never existed and does not exist. What we know of, I mean our client knows of is this document that was filed with NEC July 14, 2020.
So we take another question from.
Okay, so my name is Trojan.
And who is serving on the agenda?
My name is Trojan. Yes, sir. What is your fear here? Looking at the situation you just outlined about the case being misdemeanor, first degree, you talked about, of course, it being a political case. You said, of course, that there is no private lawyer assigned to fight the whole government case against you. What is your fear here? Because in this case, it has less as you really need to sound like, but all of the money, all of the effort they made by the government to make it look like a very big case. What is your fear?
We have no fear. If we had any fear, we would not have come to this stage. We would not have had this press conference.
I mean, at the end of the day,
we are very confident. We have respect for the court system. We trust the court system. We have explicit confidence in the independence of the judiciary. And we believe that all we can do is to go to the court and provide adequate legal representation. And I have told you what we believe is that Mr. Cummings and others are innocent. The charges are trumped up. They are concordant. They are well planned and calculated to tarnish the high-end reputation and or distract him from his political agenda. So we have no fear, absolutely. And if your question is intended to say that we are afraid that at the close of the day we may not get justice, absolutely not. We have explicit confidence in the independence of the judiciary in the integrity of the judge that is in this one.
So, given that time is fast spent, we'll just give one more chance. And then after that question, then we'll adjourn the press conference. So,
thank you. My name is Stephen Ramos, and I report for Joy. Sir, I want to know from you, from the stage where the case has reached, you have told us that you have submitted a document to the city court. We also want to know from you, recently you spoke to the press regarding an appeal to be taken to the Supreme Court. Where are we? I mean, is the ANC or Mr. Cummings going to take an appeal also regarding the matter that was filed on by the criminal court?
Those options are available. I mean, the client ultimately will make the call. But those are options available. Right now, the decision has been made that we proceed with the trial because we want to get into the substantive nature of this case. So all of the shenanigans carried out by the state prosecutors, we're not interested in that. We want to get to the truth of this matter. So the options are there, available to us. And we reserve that right, the clients reserve the right to take them when in fact they deem necessary.
I think I told you in one of my presentation that right that we have to go on appeal, we have not, and the defendants have not made that right. The fact that when the circuit judge made a decision, we accepted to his decision, and he noted it on the record, means that the right to a review of that decision by the Supreme Court, the defendants still have it in the event that matter goes on appeal. So it means that they have not waived their right. Without prejudice to their right, they are submitting to the magisterial court because we do not want this matter to delay any further. This is 45 days they are going. The speed with which the Solicitor General was moving and writing releases, the weight of the evidence that he said he has, we have given careful consideration to this to say, let's come back and let him have the opportunity to come and produce the evidence that he said he has, so the public itself will get to know it and that will close this matter once and for all. So we have made that tactical, the defendants have made that tactical decision. And so that right remains reserved while we come to the magisterial court and pursue this matter. We hope that the next time we appear, they will produce their witnesses and will commence the actual trial. They've named witnesses such as Joseph Walker, Nobly Kanga, Mo Ali. On the list they provided, those are their witnesses. Look, I'll be glad if they were to come to testify, because I can tell you only the truth can survive a rigorous cross-examination. To lie is difficult on a rigorous cross-examination. And if you come and lie, the Liberian people will get to know who they are. I hope that answers your question.
Thank you.
At this stage, I want to say thanks for coming, and I will now join this press conference, and wish you safe travel to your respective places of work.
Okay, these are the complete documentation for the exhibit.